another brilliant thing, and Tim has this ability, and so does Ted. I've seen Ted to it, where you can read a room. You can tell if they're going with your PowerPoint, and if they're not, you can change on the fly. That makes an attorney good, because they can change. And that's what makes a trial tech good as well, is that you're not locked in. You can't be boxed and locked in, because a really good attorney is going to flip the script on you, because they're going to go with the fact that, oh my God, these people are not with me. They're all stone-faced. They're not agreeing with anything. I need to make a change.
I think the other thing that lends to kind of what we do with the good lawyers is the good trial lawyers figure out how to take this much information and try this much information. And what separates the pros from the rookies are those that can try a case with a little bit, with just they got to narrow down. Everything's important, but they have to narrow down to a 4-day trial. And it goes back to the old Mark Twain letter. You know, sorry for the long letter. If I had more time, I'd have written you a shorter one. Which basically is, the more time you spend, the more you figure out how to whittle it down. Good trial lawyers, besides the fact when they get to court, they're like, we're not going to do this. I'm like, we worked for 2 years on this very issue, and no, we're not going to try this, we're going to try that, we're going to this, and that. 8 of the 50 issue points that we could make, we're going to do those 8. The other 42, we are not going to go do. Yep. And sometimes they pick the wrong 8 and lose the case, you know.
The same thing. Some people are artists at it, and some people are just hackers at it. Somebody who really knows what they're doing is, it doesn't come without a good deal of experience, but anyone up here is, I know both of these guys do the same thing, and basically when we're in court, we're listening to the case, and we're listening to the facts of the case, and we're watching the jurors and seeing if they're getting it, or if they're not, and if they, where we find the case is weak or strong, we feed that back to counsel, and we let them know, because we're closer to the jurors than we are the attorneys. I mean, as far as our perspective, our point of view. Yeah. So we're trying to offer that back. But also, when there's an exhibit up on the screen, you've got a lot of options there. While the attorney may say, let's see exhibit such and such, let's go ahead and zoom in on the paragraph, whatever it may be, and it's zoomed in. And that's the last thing he might tell you. And as he examines the witness, and he's going through that exhibit and going through the language in there, and then as you're really paying attention, following along, listening to the emphasis, and you may not even know what the emphasis is yet. You may or may not know. And if you don't, you're listening, you're trying to learn, and as soon as you get a clue where he's going, what's important, what is he or she talking about, where's he trying to make that connection with the jury, and then as soon as you figure that out and you're sure of that, go ahead and highlight that text. He doesn't ask for it, nobody knows it's coming, and it just happens. And what you're doing is doing something actually called arguing the document.
Part of the art is also, when the time's appropriate, to blank the screen.
Blank out.
Like, we're done and we're on a new topic, and let's focus back on the witness or so forth. And we never get told sometimes, go ahead and take that. The first, they'll say, go ahead and take that down, and you just say, you can say thank you or so, but after a while you figure, all right, they've seen enough, they got the gist, they've done the highlighting, Ted has done, but boom, get rid of it, and black screen, focus back on the witness or the lawyer.
And part of that decision might be based on watching the jurors too. If you feel that he's already, counsel is moving on to another topic, and you should blank that screen, take a look over the jurors. And if you see them looking up, copying down the notes or something, don't get rid of it.
No, don't get rid of it, because if you've got a medical bill summary up there and they're writing down the numbers on the medical bill summary, and you're working for the plaintiff and they're writing numbers, don't take it down. Let them write and watch all of them, and watch when their pens are done. I've got an attorney I worked with 2 or 3 weeks ago. We were in trial, and during opening statement he never turned around. He never looked at the screen. He was talking to the jurors, and he came back, and his paralegal, she said, well, I just can't believe he never turned around and looked at the screen. And he looked at her and said, I knew he'd be there when I called for it.